Good night, Belizeans at home and abroad. This is the Belizean Affairs Show number 472. 472. My name is Leonard Brackett. I'll be your host and co-chairman for tonight, and we're looking forward to presenting you with a fair enough program that will worth your time and effort expended. To those who may be listening to us live, in a little while, I would like to ask permission to break for for a minute or so, and just allow the other listeners to be brought in on the other um, platforms. Nevertheless, we will proceed with our program as we normally do, which is to say a short prayer, after which we do a short reading. I'll do the prayer right now. Divine loving Father, once again we come before thy presence, asking that thou would accept our humble expression of gratitude and thankfulness to you for having given us the privilege of life, first and foremost. And secondly, for the privilege and the opportunity to still be alive among our family members, friends, and loved ones today. Please continue to bless our country of Belize, its people and leadership. Please bless this country also. Please bless the rest of humanity. Please bless our family members, friends, and loved ones, each and every one of them. Do not them by name and number. Do not to our hearts or desires, even our most secret thoughts, loving Father. We pray that thou mayest bless this program tonight, that whatever we have to offer, may it serve some useful purpose to the best interest of our country, of Belize and its people. We ask these mercies in Jesus' name. Amen. Thank you very much. I'll just move along and get my version of the Bible here, and let me see what book or chapter I'm going to be searching for right now. Or maybe I'll just go ahead and read whatever I open the book up. I'll read chapter 42 of the book of Isaiah, and I'll start reading from verse 14. Thus saith the Lord, your Redeemer, the Holy One of Israel. For your sake I have sent to Babylon and have brought down all their nobles and the Chaldeans, whose cry is in the ships. I am the Lord, your Holy One, the Creator of Israel, your King. Thus saith the Lord, which maketh a way in the sea and a path in the mighty waters. And that is our reading for tonight. That was making a reference. Isaiah was at that point was making a reference back to the parting of the Sea of Galilee, of the sea when the Pharaoh was chasing them, and that miracle occurred, and that's basically what it was being referred to. For those who have studied their scripture and would have an idea that particular historical issue. Um, Before kicking off the program, Papa, like I said, I would like to ask permission to just let me go ahead and log in the other platforms so that they can have access to hearing our program as well. Mhm. Okay, let me see. Oh, there we go. Okay, I need to edit post quickly. I'll just go ahead and to show to okay. Just another few seconds, please. Please. 10, six. Okay. Oops. No, I used the wrong. Okay. That's done. Okay. I'm back to the program proper. I'll start off by saying that tonight's program is going to be coming to us uh, as another teachable moment in regards to the Constitution of Belize and some of the issues that we are currently enduring. Let me see. Okay. Oops. No, too large. Too, okay. Um, I started sometime last week on this particular subject, and I would like to pursue it a little bit more because I want to get into some of the weeds, in the garden in terms of all these criminal activities going on in our country under the color of law by those who are supposed to be our lawmakers and our governance institution and personnel. Part 10 of the Constitution of Belize, under the category listed as miscellaneous, at section 121, subsection 1 reads as follows: the persons to whom this section applies shall conduct themselves in such a way as to not place themselves in positions in which they have or could have a conflict of interest. That's a constitutional requirement for those who are doing or meddling with and or in charge of exercising powers of governance. As per paragraph A, they are not supposed to put themselves or find themselves or allow themselves to be found in any situation that is basically scampish, devious, uh, to place themselves in positions in which they have or could have a conflict of interest. Paragraph B goes on to say, or to compromise the fair exercise of their public or official functions and duties. And that goes down from the Governor General all the way to smallest person in the various departments of governance, whom are supposed to operate in an honorable, legal, lawful, and constitutional manner, as expected and stipulated here by the Constitution, from which I'm currently reading under Part 10, Section 121, subsection 1, and Part A. And I'm going to, I just read Part B just now, and I'm about to go ahead and read Part D, Part C. Neither should they find themselves in use of their office for private gain. We know currently we are suffering a lot of those ills as regards to the Defense Department and all the shenanigans that came out, documents that came out that shows the level of corruption that's going on and has been going on in that department, as well as other departments. For example, under the Forestry Department, under the Lands Department, and many others, as I previously stipulated. But just let me go ahead and finish read what is written here in the Constitution. As for Section D, Paragraph D, they are not supposed to demean their office or position. And I don't see how they are not demeaning their office by running mafia scams, ripping off the treasury under bogus and false pretense. Paragraph E, they're not supposed to allow their integrity to be called into question. Or, well, as I'm saying right now, I'm calling it into attention, and there are many other individuals who are calling their type of behavior into question as being malicious, malignant, and as well treacherous and treasonous for misappropriating and stealing the national assets, especially as regards to the Defense Department, while the people in the Defense Department, the soldiers, are out there in the bushes living a hard life. You got these mobsters running away with millions of dollars under false pretext, as if that money was, which was appropriated for the military, is being used correctly. And paragraph F, it goes on to say, or to endanger or diminish respect for, or confidence in the integrity of the government. Subsection 2 of Section 121 goes on to say, as I previously stipulated just now partially, this section applies to the Governor General, members of the National Assembly, members of the Belize Advisory Council, members of the Judicial and Legal Service Commission, the Security Service Commission, or the Public Service Commission, and members of the Elections and Boundaries Commission, public officers of statutory corporations, such as the dastardly deed that we have with Mr. Bacon Lizarraga trying to steal money from our publicly owned company because he was appointed as a director to represent the shareholders of the company, which are us, the majority shareholders, the people of Belize, and the government of Belize. And this jackass will come to us and tell us in public that company that he was put to be the chairman of the board of, they can go ahead and have their meetings in secret without the Belizean people know what kind of secrecy, scandal mongering they're carrying on with, and what kind of mischief making they're doing in ripping off all funds to give to their own private colleagues, under the idea that he is running our public business as a private enterprise on his behalf and with the guidance of the minority shareholders, which is only one board member to start with, and all the other board members, because we have the majority of the ownership of the corporation through or government investment, through Social Security and others, that he should try and enable some of his scoundrel family members and friends, including the Prime Minister, to be able to, behind the scene in their board meeting, steal from us, the public. Is this guy crazy, or just think that we are stupid or something out here? I see someone in the background. It's the chairman for tonight. So he's going to come on when he's ready. He's able to bring himself on. So I'll just rant a little bit more until he's available. Let me just continue reading this section 121 of the Constitution of Belize, subsection 2, which describes the individuals under who comes under this particular constitutional mandate. So this idiot of a chairman of the board of BTL, which is a publicly owned and controlled company with majority shareholders, according to him, he is not there to represent our interests or the government interests. He is there to represent the interests of his family members, who are not members of that board, by the way, but on whose behalf he's going to force this board under the color of law, behind the powers of governance, to dispossess the government and us, the Belizean people, of $88 million in one instance and another $110 million in another instance. And we are supposed to be just, satisfied with that, because they go ahead and make those votes to say that they're going to go ahead and buy these other companies, which are outdated, which are basically, all they're trying to do is help somebody else to cash in on our money under the pretext that they're buying something that our BTL needs. Then after they were caught red-handed, they turn around and say, well, they're not buying the whole equipment, they're just buying the clients. If they don't want to stay in business, how they are out of business, and those clients will migrate to whoever can provide them the services that they need or require. But these jokers are going to pretend that, well, they have to, the board members, one of whom had left the board because of the same issue and made it public, that board member was replaced with somebody else who was suborned to go along with the stuff. And as soon as the breeze blew over, they turned around and they got on and sat and had the other meeting and decided to vote in favor of this criminal activity, in favor of this highway robbery. They all belong to go to jail, or they should be sued personally for the level of honorousness and malignancy and self-enrichment and enrichment of their family, friends, and others at the public offer. But they won't prosecute themselves, like I said, because the Prime Minister is also involved with the process, while pretending that, well, it's only his family, not him. Anyhow, our chairman for the night is available, so I need to cease and desist. Mr. Chairman, can I just finish read this little part here that I was reading, sir? It's not going to take too long. Just a few more words, and I don't think I'll comment on it anyhow. I'll just wish to read it so people can hear what the Constitution was saying. No?
Proceed.
Thank you. Thank you. So, section 2, subsection 2 of section 121 goes on to say, this section applies to the Governor General, members of the National Assembly, members of the Belize Advisory Council, members of the Judicial and Legal Service Commission, as well as the Security Service Commission or the Public Service Commission, and members of the Election and Boundaries Commission, as well as public officers of statutory board or corporations of which Mr. Bacon Lizarraga is a member, and government agencies and such other officers as may and such other officers as may be prescribed by law enacted by the National Assembly. And I'll deal at that, Mr. Chairman. Thank you for allowing me the privilege to complete that part of the constitutional reading, sir. I yield back. Mr. Chairman? Greg? I wonder if you're frozen. Hello?
Thank you, Mr. Brackett.
You're welcome,
I want to say good night to you, the people at home and abroad. Thank you for tuning in to this 472nd edition of Belizean Affairs. I want to thank you for sitting virtually with me, Mr. Brackett.
Thank you very much, Mr. Chairman.
Our other host is being occupied for the time being, but hopefully he will be back with us as soon as possible. Tonight, I want to run through the BTL SpeedNet saga, and I want to break it down to the people so they can understand what is at stake and how the present government intent to violate the Belizean Constitution to make this deal go through. Let me go to the tape to hear what some of the individuals and the business senators had to say.
We stand on the same ground to lose, just like other Belizeans, if this amalgamation moves forward. With the switching of technology, there was a time when the powers that be would have to either turn off your transmitter or revoke your license. But the way things work now with IP addresses, etc., they could damage the media output without us even knowing. The world has changed. It doesn't make sense that our constitution gives us freedom of conscience, but constantly we are fighting for freedom of expression and freedom of speech. These things go together. It's like you could think it, but you can't talk it. I think we in the media represent various perspectives, and we really should have that right to continue to have these individual perspectives.
Historically and institutionally, CREM and Channel 7 in particular, both started their operation, Channel 7 in 1981, CREM in 1989, against a situation of state censorship. So when Channel 7 started in 1981, George Price, then Prime Minister, Premier into Prime Minister, said that the state reserves all right for such broadcasts. When CREM started in 1989, it was the then UDP administration who did not want to license anybody other than Radio Belize. So I'm saying that our DNA for our organizations is grounded, is rooted in a resistance to oppressive situations where there is not a plurality of opinion being shared. And I think that any state-controlled monopoly poses a danger to free media. Any fettering of the free media poses a danger to a democracy's functioning. And once that happens, all hell can break loose. And for us to move back to a monopoly with the sanction of the state-controlled directors is a very chilling event, and I hope that the PUC acts in the national interest and according to the law and intervenes to stop this madness that just continues without the regulator saying anything. The regulator as an afterthought. It's an embarrassment to the PUC. And I hope that the directors appointed by the Prime Minister will have some shame and take up their duty.
No change. Still the same. We oppose. He'll have the lived experience of seeing where absolute power in control of a monopoly. Because if we say monopoly, they're not the complete facts, you know. That one monopoly in the hands of absolute power. The government have the control. And we experience certain punitive measures because of positions we have taken. You're vulnerable, especially now, more so than ever. The importance of the technology to the kind of work we do and how we reach our audiences and how content is distributed. We just really, and it's not just the only aspect of it, it's the leading aspect of it. It is unacceptable.
People at home and abroad, before I make any comment on this tape, I would like to go to my cousin first, because here we are in a situation where the separation of powers is not working in our country. In fact, everything has been done through executive powers in violation of Section 6 of our Constitution, which specifically says everyone should be treated equally when it comes to law. I go to you, Mr. Brackett.
Thank you very much, Mr. Chairman. In regards to the section that you quoted, section 6 of the Constitution, where all of us, according to the Constitution, not according to the government, or according to any minister, or according to the Prime Minister, or any other individuals, according to our Constitution, which is the supreme law of our land. The Prime Minister cannot just one day get up, or any other minister one day get up and say, well, they're going to make a statutory instrument to trump the Constitution, to take away our rights or to suppress our rights, either by making laws and or by using the military forces to implement unconstitutional laws. Because the Constitution does not contemplate that we end up with people that are so onerous to the point of dismissing the Constitution and just brute force, want to force their way and scampish behavior down the throat of the populace against the populace will. Those are the kind of things that creates revolutions in countries. Because it is not expected that people who we entrust our governance powers to should be making any rules and regulations or any policies of state to harm the people or to rip off or steal from the people or to penalize or be punitive to the people or to create or try to pretend to create any law by any means to transgress or trump the Constitution. Whenever a government gets to the point of trying to trump the Constitution, because we can only have one Constitution at a time, it means then that they're overthrowing the Constitution and the system under which that Constitution allows for their own governments to exist. Which means that they're bastardizing the Constitution and its intent, and they're abusing the populace. That's intolerable. And these fools, because they feel like they have the military behind them, they have the impression that they can just haul and pull the system any which way they want and ignore the Constitution when they so choose. They cannot be stealing any assets from the people. They cannot be getting so upset under the color that they want to silence the people, telling each other what's going on with their government and complaining to their government. But it appears that these guys, they want to do what they want and forgetting that they were elected to do what we want them to do. They're not elected to control their own powers. Those powers belong to us, the people of the country. They're just servants. They're employees. They asked to be given a job. They're getting a salary for that job. And if they don't want to perform the job, give back the salary or get the hell out the way. They can't muzzle the people with the people's power. At least they're not supposed to. In regards to the issue of the BTL, the gentleman they were talking about, it is much more than just what they said. Of course, each of them are trying to speak on one particular part of it so that the others could get a chance to say their own piece. But at the end of the day, the Prime Minister has no legal authority for him to allow BTL to go ahead and use the public funds or assets that belongs to any statutory body, which also belongs to the government and we the people, who are the government, by the way. The Prime Minister is not empowered with any powers to commit a crime. Otherwise, he should go to jail just like any other criminal. There's something here. Mr. Chairman, can you go ahead for a second, sir? I need to check something here on my laptop. I'm getting another message. Are you, sir?
Thank you, Mr. Brackett. I want to say this to you, the people at home and abroad. The Telephone Act, the Telecommunication Act, is an act of Parliament, and it is enshrined in our Constitution. Any other statutory body gets its powers from the Act, which is the Parent Act. And while we have the PUC, which is to carry out regulations, there is no minister that can write a statutory instrument to trump our Belizean Constitution.
Or the Parent Act, as you have just described it.
And tonight, I want to prove that to you, because recently the government of Belize and the legislators have been coming up with informal laws. The Constitution has set forth how Parliament can make laws, but they should not be inconsistent with the Constitution of Belize. But they continue to make amendment to the Constitution and amending the Constitution informally instead of formal. And by doing this, they are trying to take the powers from the Parent Act, and they cannot do that. I would like to go to a video so you, the people at home and abroad, can understand exactly what I'm trying to say when we have the legislators overreaching and making informal laws that are ultra-virus to our Constitution. Let's go to the tape to hear another piece of law they are trying to make beside the taking over of SpeedNet. Let's go to the tape.
In terms of the places where it will be protecting people from secondhand smoke, you will have any indoor workplace, reading from the bill itself now, any part of any public place that is an indoor space, any means of public transport, any means of transport at the time transporting a child, very important, and a person shall not smoke in the following outdoor places: any area within 8 meters from a window, anywhere on the premises that is 5 meters from the outside boundaries of any public place, any waiting area, park, playground, amusement park, stadium area, historic site, public space for the service of consumption of food and drink, any public place where smoking may pose a fire or other hazard, or any other outdoor public space specified in the regulations. Very encouraging, Mr. Speaker. And I would also like to mention that in the second schedule, examples of public spaces, public places where smoking is prohibited: government buildings and compounds, all health institutions and facilities, public or private, all educational institutions and churches, public transportation including terminals, childcare facilities, very encouraging, private business where the public accesses services including lobbies of banks, hotels, restaurants, bars, cafes, and other eating or drinking establishments, entertainment facilities including clubs, cinemas, concert halls, theaters, and game arcades, gaming machine venues and casinos, publicly owned facilities.
I want to stop it there because this is exactly what I am speaking about when I was saying the government is making informal laws that is inconsistent with the Constitution.
Overreach.
Now you hear what the lady had to say. Now, casinos and bars who pays a trade license, and this is how they make their money. They are trying to step in and tell them that they will not be able to allow smoking on their private premises where they have their gaming machine. Now imagine, this is totally unconstitutional, and I will prove it tonight. I go to you, Mr. Brackett.
Thank you very much, Mr. Chairman. My first comment in regards to what Ms. Valderramos was stipulating in that proposal is that because they are coming from an onerous perspective, they're not able to parse the reality of what a bill like that would do compared to what a bill with similar ideas or objective could accomplish while still being constitutional and not being overreaching and onerous. But their mindset is such that power corrupts, and absolute power, which they claim that they have, is corrupting them absolutely. They don't give a damn about the Constitution or anybody else or anything else other than what they want to have pushed down people's throat. That's the problem that we're dealing with. We have a government with a supermajority in the House of Representatives who believe that they can go to the House of Representatives and make just about anything that comes out of their head become the law of the land. And Ms. Valderramos is also a lawyer. So she should be more than cognizant about the fact that those kind of onerous attempts to bastardize the Constitution or to create laws that the Constitution, before they create it, already deemed those potential laws to be null and void. For her as a lawyer to go to the House and make that kind of stipulation that she was making and not recognizing that she is overreaching broadly and in a nonsensical way to start with, because wasn't this the same government that tried to push the marijuana bill, Mr. Chairman? Wasn't this the same government that tried to push the marijuana bill on the people?
You're correct,
and
Mr. Brackett.
the people rejected it, and they turn around and they try to went to the little island Kikaka, to see if they could have gotten the people out at Kikaka there to vote for it under the idea that they was going to be doing it to provide a safe haven for the tourists to come and be able to smoke their marijuana there on the island, with the idea that if they can get the island to do it, then they'll be able to push it in some other jurisdiction and eventually get their way, despite the fact that the public was telling them no. So which side are they on, or what is it that they're trying to achieve? Even if they wanted to clamp down on the smoking per se, for any medical reasons or whatever other reasons, those two things are not compatible under the present and the same one only constitution at a time, unless they're hoping to change the constitution as they have indicated before. And these new things that they're proposing now would fall under the new constitution, but they got to get there first before they can leave from here. Those laws cannot be legal, lawful, and constitutional under this present constitution. And they can't be proposing laws now under this present constitution that they're hoping to have in effect when they get the constitution changed. They got to get it changed and then bring those onerous laws, which then would allow them to say they're operating constitutionally, legally, and lawfully, but not under the present law, under the present constitution. The present constitution says anything that is inconsistent with the present constitution is null and void, and to be deemed as such. Mr. Chairman, I have a lot more to say about that if we have any more time.
Thank you, Mr. Brackett.
You're welcome, sir.
But you can see exactly what I was saying, and we have been having these discussion here and Belizean affairs for months. We have been stipulating about these informal laws that the government is doing.
But they're not consistent, sir.
It is not consistent, Mr. Brackett.
They're either sick in their head or they have a mental problem.
It will not be consistent because if it's not helping them to make money, then they are against it. You saw what happened with the referendum they had in Kikaka for the marijuana.
Yes, sir.
Had that passed, they would have been making money. And then they would have tried to do it in other places in the country. But because it did not pass, now here we go, they turn around and wants to come with something new that is detrimental to the Constitution.
And the people.
So, these are just some of them that they are doing in violation of the Constitution. So tonight, people, as I said, I want to go to a tape so you can understand what government overreach is.
Mr. Chairman, before you go to that tape, sir, on this same one that you just played, they have no power and authority unto themselves unless they come to the public with a referendum on these matters that they are trying to push as law to contravene the public's constitutional rights. They have no such power yet, and they are unwilling to go through the process in order to acquire that power. They're pretending that because they are the government, they could dismiss the Constitution and just run the country any which way they want and create any bogus policies or procedures or policies of state that is unconstitutional, and pretend that, well, they created it so they won't run it like that. At that point, they are becoming scofflaw. They're not only just being violative of the Constitution, knowing so, but they're dismissing it, lock, stock, and barrel. They, for example, they cannot go and tell, like you said earlier, the business people how to conduct their business. The Constitution says that people are entitled to run their business or to make a living any which way they want however they want, so long as they're not in violation of the Belizean constitution itself. So now they want to create onerous laws to deem people as being breaking those onerous laws, to penalize people, while they're not spending enough time putting additional laws in place to fortify criminalization acts that can be legally prosecuted. As of right now, I don't see the DPP or any other um, body in the legal system attempting to grab any of these scoundrels that are committing crimes right now under the color of law. And they will not prosecute themselves. So we need the legal system to checkmate the process. We need lawyers and we need judges to be honest and force the government to abide by the laws. We can't have a rogue government running roughshod over the system, breaking the laws themselves, while at the same time being punitive to civilians, or creating civilians, or turning civilians into criminals, or criminalizing them, making laws that are not correct so that they can entrap people with those bogus laws. And because the people don't have money to fight back, and because the government have money to put lawyers, to fight whatever case, and they can suborn the judges and mess up with the system the way they are currently doing, that these judges now they're not rendering judgment according to law, they are rendering judgment according to the wishes of the government. That's not the system of government that we have in our country, or that should be tolerated, or that the government should be allowing to have happen. They know their job. Are you back, sir?
Thank you, Mr. Brackett.
You're welcome.
I want to say this. When we speak about the Belize Constitution, this is the exact reason why I have stated nights after nights on this platform that the PCC Act will violate the present Constitution because the government is trying to get rid of our fundamental rights, Section 3 through 19, with Section 20 for judicial review. We are seeing it happening daily now. What is their intention? I want to go to another tape. Let me see if this is the tape.
We know that the sale and consumption of liquor is a contributing factor to a lot of the societal problems we're having, whether it is road traffic accidents, domestic violence, poverty, offenses, sexual offenses, labor offenses. So we know what the problems are, and we now have to bring those realities into a discussion framework. But you will also know that in that application, there are lots of challenges, whether it is with the license types, the license categories, the fees for the different categories of licenses, whether it is in the governance or administration, how the boards are appointed, who become board members, penalties, enforcement issues, the correlation to noise pollution, the playing of loud music. All of those things are creating some challenges for us as a society. We are getting a significant level of contributions, albeit from a very small list of attendees. People don't come to public meetings, my brother. But they are speaking on some critical issues, and I think what they are speaking on represents a lot of the societal views. Please come out, give your inputs, seek your clarification. Even in the current framework, if you're not clear about certain things, ask questions. And I want to say very clearly that we don't want complaints. We want to hear them, but we want solutions. We want to hear what are the recommendations.
They don't want to hear complaints.
So here we go again, people at home and abroad. The intent is to make informal law. Here we have the good gentleman speaking about alcohol and loud noise and what it does. Before we had Minister Balderrama speaking about tobacco and the tobacco bill. Before that, we have the executive overreach within our government with an unconstitutional takeover of the purchase of SpeedNet by BTL. These are all in the same category. And I will say this to you: constitutional overreach does not happen in one day. It has been happening all along, and the people have not get up and say anything. So now the government is outrightly making informal law to keep the people in check. I go to you, Mr. Brackett.
Thank you very much, Mr. Chairman. If you permit me, you alluded just now to Section 20, and I'd just like to give the benefit to the public to hear what you're alluding to in terms of let them hear what Section 20 says. Under the enforcement of protective provisions, uh, the protective provisions are those that are enshrined in the Constitution that the government cannot and should not, according to the stipulations in the Constitution, attempt to abrogate, to tread on, or to violate any of those rights. But nevertheless, as you also alluded to the point that the government or this present government has a penchant for wanting to violate those particular rights under the color of law, which is impermissible, is unconstitutional, and declared to be so as per Section 2 of the Constitution. But I want to read this section here, Section 20. It says, just a second. I need to make it a little bit smaller. I hope I don't overdo it. Okay, that's good enough. It goes on to say, Section 20, subsection 1. If any person alleges that any of the provisions of Section 3 to 19 inclusive, which precedes Section 3 to 19 precedes Section 20, which is what I'm reading 20 now. If any of the things that comes under Section 3 to 19, which are our fundamental rights, that the Constitution mandate that the government has no authority or power legally vested in it to be able to violate, and that somehow or another, we should find a way to make sure that whenever any government officials or the government as a totality, however, goes ahead and violate these constitutional rights, that people can be brought to account, even if we have to do it individually, for violate, because the Constitution is a document in black and white, it's words. It's a powerful document, but it is only as powerful as those who are willing to defend it. I hope everybody heard what I said just now. But just for the hell of it, I'm going to repeat it again. The Constitution is just a document. It is only the people who can defend the document, the lawyers, the judges, the courts, the legal system, which is why we have a judiciary as one of the 3 branches of our government, to see to it that the Constitution and what it enshrines and mandates is abided by. And as I read earlier under Section 121, it didn't exempt anybody. It didn't exempt the Governor General. It didn't exempt the Prime Minister or any other minister or any other officer or operator within government system. Those rules and regulations and the laws that were stipulated there under the Constitution goes for all of them. So none of them are exempt. But yet they pretend that the Constitution does not exist and that only what they want to do has any merits or legal or lawful authority for them to implement those bogus policies of state. If any person shall allege that any of the provisions of Section 3 through Section 19 inclusive in this Constitution has been or is being or is likely to be contravened in relations to him or in the case of a person of a person who is detained. If any other person alleges such a contravention in relations to the detained person, then, without prejudice to any other actions with respect to the same matter, which is lawfully available, comma, that person, open bracket, or that other person, close bracket, may apply to the Supreme Court for redress. So the Supreme Court under Section 20 is supposed to hear and deal with any substantive matter or allegation by any civilians that the government or any other person is trampling on any of the rights under Section 3 all the way through 19. And it goes on to say, beyond Section 20, just let me make it a little small so I can go quicker. I want to go to Section 94, 93 and 94. Just a second, I think I'm close by now. How far am I? Oh, 60 yards. I need to go 30 more. Okay. Where am I now? I went too fast. Sorry about that. Just bear with me. 98. Okay, I'm getting close. I need to get to 93 or 94. Section 96. I'm close to it. I may not pass it. Okay. I got it. Section 94 reads as follows. There shall be for Belize a Supreme Court of Judicature and Court of Appeal. Under 95, subsection 1, it says, let me just enlarge it a little, please. Just bear with me. Yeah. Under Section 95, subsection 1, it says, the Supreme Court shall have unlimited original jurisdiction to hear and determine any civil or criminal proceedings under any law, and such jurisdiction and powers as may be conferred on it by the Constitution or any other law. When we refer to other law, I hope you all remember what it means. It means not the Constitution proper, but other laws that the legislator is empowered to make. And those other laws must be legal, lawful, and constitutional. They cannot be bogus laws, or they cannot be laws that are violative, as my cousin earlier alluded, violative to the Constitution. Because then if they are violative to the Constitution, they're supposed to be deemed and pronounced as null and void. In other words, they're stillbirth. Before they were voted on, they have no life, they have no existence. They're dead before they were born. That's what the Constitution speaks to and talks about when it makes reference to lawful constitutional lawmaking, not unlawful and illegal constitutional bastardization. There's a difference. It goes on to say, provided that the Supreme Court shall not have jurisdiction to hear and determine any application made by a person sentenced to death under any law after expiration of 1 year from the passing of that sentence. Those are some precluding categories. But if we go back to 93, under Part 7 of the Constitution, I see my cousin, for some reason or another, is off. I don't know if he got knocked off by the Belizean telecommunication people under the control of the government, because they are capable of doing that, and they have a tendency to, whenever we are presenting these type of programs as teachable moments to the public, so the public can know what is wrong in the country and what the government is doing wrong, they have a tendency to try and block us off, and or they go to the House and they try to make laws to criminalize our conduct. That's the level of honorousness that these jackals pursue. They're always wanting to commit crimes under the color of law and turn around and penalize the very same people against whom they are committing these crimes. In other words, they want to criminalize us for talking about their deviancy, their devilishness, their criminal conduct and activities, and they don't prosecute themselves. The DPP has not, that I can remember, or I don't think the DPP under Mr. Pereira, way back in the 70s until now, I have not seen any of them lodge a complaint against any minister or try to take any minister to court for their evil conduct. And I've never seen the Attorney General on behalf of the government try to prosecute any of their ministers or any of the high officials then. They always try to exculpate them and try to come up with reasons to justify, just let the crime, cease and desist in terms of anybody speaking to it or demanding justice for it. We had the Bunna issue. We have the present issue with these things going on in the Defense Department with the BDF, and we have now these issues with the issue of the Prime Minister trying to give another $80 million to be shared between his family and the Ashcroft corporations then. And then there's another $110 million, which, if they succeed with this first $80 million, was part of the original deal, they will try and pull off as well, because they're going to claim that they also need those that are assets, when in fact that's a lie. I see the chairman has not come back online yet, so I'll just pursue reading a little bit more of the same section here as I was about to read. Under Part 7, with the heading of the judiciary, at Section 90A of the Constitution of Belize, subsection 1, it goes on to say, there shall be established in each judicial district of Belize, that is in the 6 districts of Belize, a summary jurisdiction court, which shall have and exercise criminal jurisdiction, and a district court which shall have and exercise civil jurisdiction. As I alluded just now, I have never seen the DPP or the Attorney General try to grab any of the ministers that have been found committing this crime for them to go and get charged and prosecuted. And if found guilty, then for them to go to jail for the crimes that they commit. They all pretend that the crime is not a crime, it has not been ruled, or these individuals who commit these crimes have not been ruled as guilty because they don't want to prosecute them. And they are coming off with this audacity or idea that if they are not prosecuted and they are not declared as guilty, then nobody should be speaking to the crimes that they commit as being crimes. In other words, it's an exculpated action. It's not a criminal action. The action, as criminal as it would be, have not been deemed by them as being a crime. So therefore, you can't say that the person committed a crime. And they keep pulling off these shenanigans over and over and over, and demanding that we go ahead and accept it. Under subsection 2 of the same section 93A, it goes on to say, the power and jurisdiction of the summary jurisdiction court and the district court shall be such as may from time to time be prescribed by the National Assembly by a law made in that behalf. Okay? Why don't they go to the House and make the necessary laws, rules, regulations, and whatever else that is required or is still outstanding to facilitate the implementation of UNCAP so that we can go and try some of these jackals? They don't have no time to be able to get that done, even though they offered to do it before they got elected. I know they are being elected for the second time again. They're into their second term in this present cycle. And they're making all kind of bogus laws that don't have nothing to do with keeping them in check, stopping them from misappropriating and misusing and stealing their assets. That's what people are concerned about. People have to be paying all these high taxes and are being squeezed right, left, and center at every instance, just in order for them to collect extra or more money than they actually need to spend, that they actually end up spending, and then the people are not supposed to complain. We're just supposed to be acting like some modern slaves, you know. It goes on to say, under subsection 3, it says, a magistrate shall be appointed by the Judicial and Legal Service Commission and shall, subject to any law passed by the National Assembly, be a qualified attorney at law as a minimum. I added the last word, as a minimum, last two words. Under subsection 4, it goes on to say, we still have a few more minutes to live. Subsection 4 says, a magistrate who is a qualified attorney at law shall have security of tenure and subject to any compulsory retirement age for public officers may be removed from office. Only, I see our chairman is back. I'll just cease and desist and turn back the program over to him. Are you back, Mr. Chairman?
Thank you, Mr. Brackett.
You're welcome, sir.
I was having a little technical difficulty, but back to what we were speaking about. When I said that we are living in a time when we have no separation of powers and executive overreach has been used often. People at home and abroad, I want you to listen to the tape. I have given you 3 scenarios of government overreach. One is with the tobacco legislation. The second is with the alcohol bill they're trying to pass and noise. And we already know about the BTL saga. Let's listen to the tape.
The term ultra vires is a Latin phrase that means beyond the powers. In legal terms, the doctrine of ultra vires refers to acts or decisions made by a corporation or government entity that fall outside the scope of the powers and authority granted to them by law or corporate charter. Such acts are considered invalid and unenforceable because they exceed the legal authority of the entity that performed them. Significance of the doctrine of ultra vires. 1. Legal control and accountability. Ensuring compliance. The doctrine ensures that corporations and government bodies act within the limits of their legal authority, promoting accountability and legal compliance. Protecting stakeholders. It protects shareholders, creditors, and the public from unauthorized actions that could harm their interests. 2. Maintaining legal order rule of law. Adherence to the doctrine supports the rule of law by preventing entities from exceeding their legal mandates and acting arbitrarily. Types of ultra vires acts. 1. Corporate ultra vires. A. Definition. Corporate acts. In the context of corporate law, ultra vires acts involve actions taken by a corporation that are beyond the scope of its corporate charter or the powers granted by its articles of incorporation. B. Examples: unauthorized business activities. A corporation engaging in business activities not specified in its articles of incorporation. Invalid contracts. Entering into contracts that are outside the scope of the corporation's defined purposes or powers. 2. Governmental ultra vires. A definition: governmental acts. In the context of administrative law, ultra vires acts involve actions taken by government agencies or officials that exceed the authority granted to them by legislation or statutory provisions. B. Examples: regulatory overreach. A government agency issuing regulations or directives beyond the scope of its enabling legislation. Misuse of power. Government officials taking actions or making decisions that exceed their legal authority. Judicial remedies and consequences. 1. For corporate ultra vires acts. A. Invalidity and unenforceability. Legal status. Ultra vires corporate acts are considered void and unenforceable. Contracts or transactions beyond the corporate powers can be declared null and void. Restitution. Parties affected by ultra vires acts may seek restitution or reimbursement for any losses incurred due to the invalid actions. B. Shareholder actions. Derivative actions. Shareholders may file derivative lawsuits on behalf of the corporation to challenge ultra vires acts and seek remedies. Injunctions. Courts may issue injunctions to prevent corporations from continuing unauthorized actions. 2. For governmental ultra vires acts. AI. Judicial review court challenges. Individuals or entities can challenge ultra vires actions of government bodies through judicial review, seeking a court declaration that the actions are invalid. Quashing orders. Courts can issue quashing orders, certiorari, to nullify ultra vires regulations, decisions, or actions. B. Compensation and injunctions. Compensation. Affected parties may seek compensation or damages for losses suffered due to ultra vires governmental actions. Injunctions. Courts may issue injunctions to restrain government bodies from engaging in actions that exceed their legal authority.
So there you go, people at home and abroad. I could not have put it any other way than you heard from the tape. So if you were not enlightened or you were not sure about what executive overreach mean and what this BTL SpeedNet takeover means, there you have it. You can go back to our show number 472 and look and listen to what we have said here, because this is to enlighten you, the people at home and abroad. I go to you, Mr. Brackett.
Thank you very much, Mr. Chairman. And that was a very nice presentation, contextually within what we were discussing, and a reinforcement in terms of the definition of the terms and the circumstances that prevails in this particular SpeedNet BTL issue. And it goes beyond the BTL, the SpeedNet, because like I said, the SpeedNet BTL issue is a $80 million rip-off or hijack, but there's also 110 million more for the other smaller companies that one of them belonged to the chairman of the BTL board, who was trying to hustle the Belize people by trying to buy his family property so that they can enrich themselves at the public trial. My problem is the board is entitled to have meetings and make decisions that are not onerous. They cannot sit as a board and make any decision to dispossess the company of any assets that is publicly owned, that they are in control under their management of. That's a crime unto itself. In some areas, like here, for example, in the United States, they would call that insiders trading, where they take the knowledge to acquire and dispossess the company of its assets, or to acquire other assets that belongs to other outside people or the people who have elected or put them in power. They are there to represent the Belizean people. But the Prime Minister, as a technical way of representing the Belizean people, is the person who appoints them on behalf of the Belizean people to look out for the Belizean people's interests. They're not supposed to be there to look out for the Prime Minister's family interests above that of the owners of the shares. They're fiduciary. They're there as fiduciary agents on behalf of the people who own those shares. So they should not be doing any hanky-panky behind the scene and at that trying to declare themselves to be independent enough, classifying themselves as a private entity or as a private corporation. How the hell did they get the word private along with the word corporation when it comes to people's public business, when it comes to public assets, when it comes to a company that is majority, not only just by a small majority, the majority of the majority of the majority of that company is public assets. The people who own a few shares in that company as private individuals doesn't own not even 1/5 of the asset or value in that corporation. As a matter of fact, among all the directors, they have only one person representing them as a token. All the other directors represent the government appointed by the Prime Minister. But it's because it is the Prime Minister's family who's supposed to get enriched by this particular endeavor that they're doing. The presumption is that they're doing a favor to the Prime Minister, while at the same time the Prime Minister is claiming that, oh no, they're not doing any favor for him because he don't have nothing to do with it. They're under duress because of the pressure that he is putting on them. He is the person that's supposed to direct them how they're supposed to vote their shares, other than the Belizean people. He is the intermediary between us, the Belizean people, who own those shares by virtue of owning the assets. And because he is our Prime Minister, he gets to appoint those board members. But those board members have a fiduciary duty not to the Prime Minister, but to the people who own the shares. And if they're going to vote to carry on the illegal conduct that they're trying to carry on there, and the Prime Minister will have nothing to say about it and pretend that he have no control over them, or that he is not responsible to act in our behalf or in our interest with our assets, then he is failing his fiduciary responsibility as well, because he's also not only just Prime Minister, but Minister of Finance. And he is in business with Mr. Ashcroft. Okay? That's how come his family end up holding that asset. But initially, he and Mr. Ashcroft were in business together. And Mr. Ashcroft, out of that $80 million, is going to get $62 million. And the Prime Minister family and others will split the other 18 million. If the deal was so good, why didn't somebody sell it privately to somebody else for a better price? Why is it that they are coming to the public car first to try and squeeze money out of the public coffers with the acquiescence of the Prime Minister. That deal cannot go through without the Prime Minister's acquiescence. Are you back, Mr. Chairman?
Thank you, Mr. Brackett.
You're welcome, sir.
We are here speaking about this BTL saga, and if you listen to what is being said, it sounds ludicrous. As to the Ashcraft, they are not buying the equipment, they are buying the cash flow.
Crazy.
Now imagine you're buying the cash flow. So, in other words, if that is what the public-private company called BTL is doing, that is as safe as saying, well, we're not going to use the equipment. We just want to buy over the cash flow, which is the people who is invested in Smart SpeedNet. But apart from that, I want to say this specifically to you, the people at home and abroad. Tonight, I have showed you, I have tried to enlighten you on how our great Constitution is being bastardized by our present government. Again, I want to repeat tonight that I personally don't see no reason for the PCC Act to write a new constitution, because the intention of government is not to write one for its people, but to take away from your fundamental freedoms, Section 3 through 19, with judicial review to protect you. The intention is to continue to make informal laws that is null and void with the Constitution. And all these laws that are being made informally is, as anyone can see as plain as daylight,
Overreach.
has to do with authoritarian ruling. So, again, I would like you to kindly take your time and listen carefully to what is being said. With that said, I go to another tape to enlighten you, the people at home and abroad.
Welcome to Law Pulse YouTube channel of administrative. Please subscribe the channel, and today let us discuss about the judicial control over delegated legislation in the subject administrative law. So first of all, let us know the meaning of this judicial control of delegated legislation as such. The delegated legislation refers to rules, regulations, bylaws, or orders made by an authority such as government, administrative bodies, or local authorities under powers conferred by an act of parliament or state legislature. It helps parliament in managing technical or detailed matters without enacting a new law each time. So that is the meaning of the delegated legislation. Then coming to the factor, the need of judicial control, need for judicial control. The parliament delegates legislative power for efficiency but must be controlled to prevent misuse. Judicial control ensures that a delegated legislation stays within the limits of the authority granted by the Parent Act. It ensures of law and protects citizens from arbitrary exercises of delegated power. So that is the need of judicial control. Then what is the basis of judicial control? So the judicial control operates and exercises in two main grounds, or on two main grounds. That is, one is substantive ultra vires or procedural ultra vires. So these are the two important grounds of judicial control to exercise the powers. So coming to the substantive ultra vires meaning, what is it? What is the substantive ultra vires? It occurs when delegated legislation goes beyond the powers conferred by the Parental Act and when it violates the essential purpose of the Empowering Act. So these are the two grounds of substantive ultra virus. The example for this substantive ultra virus is a bylaw allowing the detention without any justification when Parent Act allows detention only for specific reasons. And coming to the kinds of substantive ultravirus, this is rather very important. So, first, the kind is the excess of power. So, what do you mean by this excess of power of substantive ultravirus? When the delegated authority makes rules beyond the scope of the Parent Act, for this, the best example is the Parent Act empowers framing of safety regulations in factories. Instead, rules about taxations are framed. So, this is one factor of the kinds of substantive ultravirus. And the second factor is contrary to constitutional provisions. How it will be? So, this occurs when delegated legislation cannot violate fundamental rights or constitutional provisions. For this, the best example is the regulation restricting the freedom of speech without a valid basis and violates Article 19. And the third one is unreasonableness. The unreasonableness is even if within the power of the Act, if the rule manifestly unreasonable, courts can strike it down. For example, a rule prohibiting all political meetings without any time, place, or manner restrictions. So, this is one factor as such. And then the repugnance to Parent Act. When a rule contradicts the Parent Act, it is ultra virus. The example, the rule permits an action forbidden by the Parent Act. So, with regard to the above substantive ultravirus, the leading cases in legal history are A.K. Gopalan versus State of Madras, 1950. So, this deals about the delegated legislation restricting the personal liberty must be backed by valid parent provisions. The other case, R.C. Cooper versus Union of India, 1970, highlighted that the delegated legislation cannot violate the constitution or fundamental rights. The other important case is Union of India where Cyanamide India Limited 1966. So this case underlines the delegated legislation exceeding Parent Act's authority is void. Then the consequences of substantive ultravirus are the rule or regulation is declared void and unenforceable by the courts, ensures accountability of the executive. Then, if we conclude the matter under this subject is the judicial control on delegated legislation, especially substantive ultravirus, is a crucial for maintaining the separation of powers and rule of law. Courts play a vital role in checking the misuse of delegated powers, preventing arbitrariness, and safeguarding the individual rights.
As mandated by the Constitution.
So there you go again, people at home and abroad. This is what is happening in Belize. We have a regulatory power in the POC which is trying to overreach and trump the Parent Act.
Cannot happen.
The Parent Act which gives them the power to regulate. They want to turn around and trump the Parent Act in an ultra-virus way. It cannot happen and it should not happen.
Can I make a comment on that statement you just made, Mr. Chairman? Just a quick comment.
Yes, it is unconstitutional and null and void. Go ahead, Mr. Brackett.
Thank you very much, sir. A clearer way of looking at it is that the Constitution is the supreme law of the land. There's no two ways about that. When they go and they make an act, for example, the PUC Act, that act itself could be made in such an onerous way or in such a way that it violates, parts of it violates the Constitution itself, while all of it may not violate the Constitution.
Hold,
But they
hold
can't.
on a second, Mr. Brackett. The
Go ahead.
PUC is not an act. It's a regulation. It's a regulation.
No, wait. I did not intimate that, so I agree with you.
Okay.
We were both agreeing on that. But I did not intimate that. I'm saying that the PUC Act,
The Telecommunication Act gives the power to PUC to regulate
the telecommunication as well as the other industries and the
right.
But
it sets
I don't
forth
think we have
the
a difference of opinion there. I'm just trying to point out something else that is
Go ahead, sir.
important for the general public who may not necessarily understand these things that you and I are discussing at the level that we're discussing it, or maybe the other lawyers who know about these things like ourselves, right? The benefits of why I'm making this stipulation here is for the general public at a lower level in terms of cognizance and understanding of these peculiarities. What I'm attempting to say is that the Constitution, as the supreme law of the land, is the base from which all other law grows, is the root and the foundation of the laws that we are governed by, which is the tree. We call the Constitution the roots, and the trunk and the rest of the body of the tree, and the leaves are us, the people who are benefiting from the interaction between this Constitution, the trunk, and the tree. We are deriving the benefit of subsistence. What I'm trying to say is that when when an act is made, the act itself, if it's a revisional act or a modification of the existing Constitution or parts of it or whatever, which the government is entitled to make, if it's enhancing the Constitution and or is working within the bounds of the Constitution, it is permissible. If it's outside the bounds of the Constitution, it is impermissible. But the issue is that if the PUC, for example, let's say the minister responsible for the PUC, he wants to go and write a statutory instrument, an SI, as he had promised to do, right, to facilitate this robbery taking place. He would have to write that SI in such a way that it honors and not dishonor the Constitution. He has to work within the bounds of what the Constitution expects or stipulates. And then the PUC cannot act arbitrarily and capriciously on the basis of that SI, especially if that SI has some onerous parts of it that is violative of the Constitution. They cannot use it because the minister made it and just go ahead and they would just agree or make some kind of stipulation or decision that violates the fundamental constitutional principle that governs their ability to act, because they are getting what you call delegated powers, as you had shown in the tape that the person was presenting just now. They are deriving delegated powers, and if those delegated powers happen to have some fault of it, then whatever is it that they end up doing can also be violative of the Constitution and is subject then for further judicial review. And the
let's
judge will then
look at it this way.
Go ahead, sir.
While the statutory body, which is the regulators, the minister can make a statutory instrument.
Mm-hmm.
That statutory instrument cannot be ultra-virus to the Parent Act. It cannot go above what it says or what it sets forth. It has to stay below it. The Parent Act, which is the Telecommunication Act that is enshrined in the Constitution, gives the regulatory body its powers. And the powers is to make sure there is competition. The regulation is to make sure that one company does not take over another company, because the way the regulation is set forth and set out is for competition.
Right.
So anything that comes and has to do with takeover is ultra-virus to the Constitution and is null and void. That is why
And we only
they
have
do
one
not
constitution at a
want to
time.
go to the House.
And
They
we
do
only have
not. That is why they do not want to take it to the House and through the Senate, because the Senate will block it and it will not pass through the House, because you cannot remember statutory instrument does not trump, and
the constitution.
policies does not trump one constitutional right.
Mhm.
You have what you call, when we speak about the Constitution administrative. Then you have statutory and policies.
Mhm.
That's the orders that they come in.
And departmental procedures and others. All of those fall way down at the tertiary level of the
Exactly.
legal chain of authority.
So there you have it, people at home and abroad. I hope tonight's show has enlightened you on our Constitution and on the ghost violation that is presently taking place between the BTL and the SpeedNet. Mr. Brackett, I go to you for a short comment and a closing, sir.
Thank you very much, Mr. Chairman. First of all, I want to say tonight's show is another one for the records, because this is what is going to go into the archives. It's one of those teachable moments, like we always say, which we do mostly on Fridays. But tonight's specific program lend itself to a lot of clarity, clarification, and information in regards to some of these subtle or technical or well, let me say it like this. Thanks to you and your contribution on the program you presented tonight, sir. I would say that most Belizeans who happen to have the opportunity to listen to our program will be a little better off for having learned something different than they would have been taught or that they would have known otherwise. Because while 98% of our people do not know the Constitution, our effort here on this particular platform to inform them or to enlighten them about it is gaining traction, and we're getting a lot of good comments, and we're getting a lot of lawyers who should be stepping up to the plate and helping to present these kind of legal and technical discussions, as well as provide substance to back up the government or to back the government down from their perches. We have a lot of lawyers in our country, very competent individuals, but apparently they are not willing to put their credentials on the line and to take up any of these issues and argue them against the government, because the government have a deep pocket and the government can pay their lawyers, while these other interested lawyers who are competent and capable would not be paid, because we don't have nobody with money behind us to pursue these objectives. So they would not be paid and the government lawyers would be paid. So most of them would kind of not want to expose themselves to having to go and fight the government on behalf of these issues. And as a result, the government rolls along with no substantive opposition to these issues in terms of court presentations. And even at that, some of the very judges that we're having right now are breaking down our legal system, are bastardizing our legal system to the point where only if we go above our local judges to an appellate court level or to the Caribbean Court of Justice, then can we actually prevail constitutionally. Our government and our lawyers and our judges shouldn't put the population of the country in that situation, because that's how you end up with dictators. And we're heading quickly towards that state of becoming a dictatorial country. We're getting close to being a failed state. You know? But I yield back, Mr. Chairman, and thanks for the opportunity to participate tonight on this great program. I call it a great program.
Thank you, Mr. Brackett. I want to say this to you, the people at home and abroad, because BTL belongs to the people of Belize. The Belizean people can show a peaceful revolution. And it is easy to do that by only buying telephone credit when they have bonus, double up. Whenever they give double up, you put enough to last you and you don't buy from them. Put the pressure on them. So you only buy when they have double up and you buy enough to last you for a time. If the Belizean people do that, they will be hurted financially and it will show what the Belizean people is trying to do. I want to thank those of you who tune into tonight's show, our 472nd edition of Belizean Affair. And I want to say that we will be back on Wednesday and Friday. And I want to also thank those of you who will tune in after we are off the air. Go ahead, Mr. Brackett.
Mr. Chairman, I would like to put out a cautionary comment. I don't think that despair is an option. So the fact that the Prime Minister himself as an individual is inclined to try and push this process forward so that his family can benefit, even when the Constitution is telling him that he's not supposed to be that onerous, I think that if people express themselves in marches, peaceful demonstrations or whatever, they can still capture the minds of some of those people in cabinet. It is my belief, I might be wrong, but it is my belief that if we can get enough members of cabinet to go up against this deal, just as was done in other occasions, it is likely that we may still prevail and still cut this thing off before it is finally consummated. The only problem
Mr. Brackett.
Yes, sir. Please.
It don't matter if the government proceed or not. If we don't proceed, then it works out in the Belizean people favor. If he proceed,
but we must still get sued by Mr. Ashcroft.
It's if he proceed, it will be a constitutional case, and if it ends up at the CCJ, you know what will happen.
But
it will be. It
for
will
it to end up there, we need people.
Case. I want to say this though. Listen to what I have to say. About a month and a half or so, I understand that the Brazilians sell their shares to Mr. Ashcroft. If that is true, and I said I believe if that was true, then it opened rooms for the Prime Minister to rectify himself by saying, I said I was not a part of it and I have no partnership or ownership in it. But what that does, if Mr. Ashcroft bought the Brazilians' share that give him majority ownership, and this deal go through, you know what that is telling me? He will sue, and he has the money to go up against.
Once the board made that decision.
So we are going right back down the same creek as we had been before.
And the last time we visited this stop, the Prime Minister stood up in the House of Representatives and told us that in exchange for a few $100 million, he was getting rid of this man out of our politics and out of our Belizean affairs. And he was settling, in his own words, all outstanding account. Only to have this gentleman still into our business, they collect millions and millions. In fact, the settling of all those accounts meant that the Prime Minister was offering that gentleman twice as much money than what the man was getting out of the port of Belize when he had it under his control under receivership. He was making like between $12 and $13 million. The Prime Minister offered $25 million per year for the next 4 years. Today, right now with the talk, and this year is one of the years that we still haven't finished paying the man.
Thank you, Mr. Brackett. But with that said, I want to say good night to you, the people at home and abroad. And again, I want to thank you for tuning in to this, our 472nd edition of Belizean Affair. Good night.